Welcome to the Deep Dive. Today, we're plunging into a world where a single misstep can cost millions, and trust is really the ultimate currency.
It really is.
Just think about this. It's quite a jarring fact. Over the last 2 decades, the UK's Big Four audit firms, just them alone, have faced fines tallying in the millions of pounds.
Yeah, serious money.
We're talking about KPMG's staggering £21 million settlement linked to Carillion's collapse.
A huge case.
Or PwC's $5 million penalty for, inadequate scrutiny at Kieran Galliford Try. These aren't just, isolated incidents.
No, they point to something bigger. They're headlines that really raise fundamental questions about accountability, don't they?
They do. What's striking is that these aren't minor penalties.
Not at all. They represent significant costs to the industry and provoke really serious questions about audit quality and even market competition.
Absolutely. So our mission today, really drawing from the source material you've shared, is to do a deep dive into this complex world of auditor liability.
Mm-hmm.
We want to unpack why these fines are happening, the intricate legal principles governing auditors, and how the whole industry is grappling with these challenges.
And the critical insight for you listening is that understanding auditor liability isn't just for finance pros.
No, definitely not.
It underpins the trust we place in our financial markets. It impacts the cost of doing business for, companies of all sizes.
Right.
And it even shapes the choices companies have when they're looking for an audit. It touches the integrity of financial reporting for everyone, really.
Okay, let's unpack this. Let's start with the landscape itself.
Yeah.
When we look at potential legal trouble for auditors, it seems to span 2 distinct realms: criminal and civil charges.
That's right. So criminal offenses, we're talking about breaches against government-imposed law, essentially the state versus an entity or person.
Okay, like the really serious stuff.
Exactly. Think fraud, insider trading. Auditors are subject to these laws, of course. But what's interesting is how specific the Companies Act 2006 is.
How so?
Well, Section 507, it directly targets auditors. It says they could be prosecuted for knowingly or recklessly causing a report to include any matter that is misleading, false, or deceptive in a material particular.
Wow. Okay, so knowingly or recklessly.
Yes, it means giving an inappropriate audit opinion, if done with knowledge or just reckless disregard, that can actually lead to criminal charges.
So that's the state prosecuting on one side. But what about, disputes between private parties, individuals or companies? That's where civil law comes in.
Precisely. And for auditors, civil law mainly involves 2 key areas: contract law and the law of tort.
Okay, contract law sounds fairly straightforward.
It generally is. If an auditor fails to meet the terms set out in their engagement letter, that's their contract, the client, usually the shareholders, can seek a remedy for that breach.
Right.
The PwC settlement with Tyco shareholders is a good example of that. It stemmed from contractual dispute.
Okay, so that covers failing to meet the contract. But what if an auditor's actions, or maybe their inactions, affects someone they don't even have a direct contract with? That's the tort part. Negligence.
Absolutely. That's where the law of tort, specifically negligence, becomes really critical. Auditors can be sued for negligence if they breach a duty of care to a third party.
The third party.
And that third party then suffers a quantifiable financial loss because of it. This is crucial because it expands potential liability way beyond just the direct client.
That's a really vital distinction.
Yeah.
So how has this duty of care, especially to third parties, how has it been shaped by the courts? I gather there are a couple of landmark cases here.
You're right. The foundational case is Caparo Industries PLE v. Dickman. That was back in 1990.
Okay, Caparo. What happened there?
Well, Caparo bought shares in a company called Fidelity Pelagi. Later, they claimed that the audit, done by Tush Ross, had overvalued the company. They argued Tush Ross owed potential investors like them a duty of care.
Okay, so they sued based on relying on the audit.
Yes, but Caparo's claim didn't succeed.
Oh, why not? What was the ruling?
The House of Lords ruled that audit accounts are prepared primarily for existing shareholders.
Well, the current owners.
Exactly. For exercising their class rights, not really for outsiders, potential investors making decisions. And critically, the auditor had no reasonable knowledge that Caparo specifically would rely on those accounts for their purchase decision.
Ah, the lack of direct knowledge or intention.
Precisely. And this case was foundational because it set up the current 3-part test for when a duty of care exists between an auditor and a third party.
Okay, what's the test?
First, the loss has to be a reasonably foreseeable consequence of the auditor's actions.
Foreseeable loss. Got it.
Second, There needs to be sufficient proximity in the relationship.
Proximity. Closeness?
Sort of a close enough link.
Yeah.
And third, it must be fair, just, and reasonable to impose liability in the circumstance.
Fair, just, and reasonable. Okay. That framework is still key today.
Absolutely central.
That's incredibly helpful. So Caparo laid the groundwork. Was there another case then that maybe pushed those boundaries a bit or clarified things, especially for specific third parties? There was, yes. And it added a really important nuance. It's the Royal Bank of Scotland versus Bannerman Johnstone McClay case from 2002. RBS versus Bannerman. Okay, what was different here?
Well, RBS claimed they lost over £13 million after lending money to a company called APC Ltd. They argued Bannerman, the auditor, was negligent because they didn't spot fraud in APC's accounts.
And RBS had relied on those accounts for the loan.
Exactly. They'd relied on the audited financials. Now, the key difference from Caparo was this. Bannerman knew RBS intended to use the audited accounts for their lending decisions. They were explicitly aware.
So that awareness, that knowledge changed everything. A duty of care was upheld.
It was. The judge concluded a duty of care did exist. And here's the really significant part. The absence of any disclaimer of liability to third parties in Bannerman's report was a major factor in that decision.
No disclaimer. So they hadn't tried to limit their liability to people like the bank.
Correct. And this case really influenced industry practice afterwards. It directly led to what we now often call the Bannerman paragraph you see in audit reports.
Right, we'll definitely come back to that paragraph. Okay, so we've kind of established the grounds for liability. Those seem fairly clear, thanks to cases like Caparo and Bannerman.
Mm-hmm.
But here's where it gets, well, really interesting and often pretty contentious. The nature of the fines and settlements. Auditors are held accountable, rightly so, but there's this huge debate around the penalties, especially under something called joint and several liability. Is it always fair and reasonable?
That's a huge question because while auditors absolutely should face consequences for professional failures,
Of course.
the system we have in the UK, and it's similar in the US, uses joint and several liability. And what this means is if multiple parties are at fault in a negligence case, say the directors, management, and the auditor, the plaintiff, the person who suffered the loss, can pursue any one of those parties for the entire amount of damages.
Wait, the entire amount, even if others were also to blame.
Yes.
So let's take your example. A director commits fraud, management has poor controls so they miss it, and the auditor gives the wrong opinion. All three messed up.
Clearly.
But the shareholders could just decide to sue only the auditor for all the money lost.
Yeah.
That sounds like just picking the deepest pocket.
That's precisely the criticism. And what often happens is the company itself might be in financial trouble.
Right, maybe going bankrupt.
Or the individuals involved, the directors maybe, they just don't have the assets to cover huge losses. So the audit firm, which is usually seen as asset-rich and, crucially, has professional indemnity insurance, they become the main target, the one party pursued for the full compensation.
Wow. That sounds like an incredibly tough spot for audit firms. What are the sort of knock-on effects of that system for the whole profession?
The consequences are really significant and far-reaching. First, you've got escalating costs across the industry, not just settling claims, but defending them. And then the professional indemnity insurance premiums, they spiral.
Which must push up audit fees eventually.
It can certainly lead to pressure for higher audit fees as firms try to cover these rising costs. And there's also a serious concern about whether there's even enough insurance cover available in the market relative to the sheer size of some potential claims. A massive claim could, theoretically, wipe out a firm.
And it must affect competition too, right? It feels like a huge barrier for smaller firms wanting to audit big companies.
It absolutely does. That's a key insight here. This principle, joint and several liability, while it aims to make sure the victim gets fully compensated,
Which is important.
it inadvertently concentrates massive risk onto the auditors. And that can stifle market competition, drive up costs. It's a major hurdle for any firm that isn't one of the established giants to even think about competing for audits of large listed companies like the FTSE 350.
Even with proposals to encourage mid-tier firms.
Even with those proposals, the potential liability and the resources needed to manage that risk, including insurance, just make it incredibly challenging for new players in that top market segment.
Okay, so given this really demanding landscape, how are auditors actually trying to manage this exposure? What strategies do they use to navigate these massive liability risks?
Well, the most obvious and frankly the most critical method is an unwavering focus on audit quality.
Doing the job right in the first place.
Exactly. Rigorously applying the rule books like the International Standards on Auditing, the ISAs, and the IESBA Code of Ethics. And we've seen a big push recently towards better quality management systems.
How so?
There are new international standards on quality management, ISQM, and an updated standard for engagement quality, ISA 220 revised in the UK. This isn't just about ticking boxes. It's aiming for a fundamental shift, embedding a firm-wide culture of quality.
From the top down.
From leadership right down to every single audit engagement, quality has to be embedded everywhere.
That makes total sense. Prevention is the best cure, right? But I imagine even with the best intentions, there are still huge pressures working against that sometimes.
Oh, absolutely. There's still constant pressure to reduce audit fees, which can sometimes conflict with allocating the resources needed for the highest quality.
The cost pressure.
Yeah. And many companies are facing tough economic conditions, making them even more sensitive to audit costs. On top of that, stakeholders now want assurance on things beyond the traditional financials, like sustainability reporting.
ESG and all that.
Exactly. Which requires auditors to upskill and adds whole new layers of complexity and potentially new areas of liability.
You mentioned earlier the Bannerman paragraph. Is that now a standard part of how auditors try to manage risk proactively?
Yes, it's a direct result of that RBS v. Bannerman case we discussed.
Because they didn't have a disclaimer.
Right. That ruling really highlighted the risk of being sued by third parties if liability wasn't explicitly disclaimed. So it became common practice to include specific wording in the audit report itself, basically disclaiming liability to anyone other than the primary client, the shareholders or members.
And what's the real effect of that paragraph? Does it completely shield them from third-party claims?
Not completely, but it significantly reduces the likelihood of courts finding liability towards third parties, certainly in the UK where the precedent was set.
But maybe not overseas.
Protection might not extend overseas, no. And critically, it offers zero protection against being sued by the client under contract law. That's a separate issue.
Okay. But does this disclaimer cause any other issues? You hinted at criticism earlier.
Yeah, there is criticism. Some argue that including this Bannerman paragraph actually, devalues the audit report. The argument is that it acts as a barrier to legitimate litigation. If third parties feel they can't sue, does that inadvertently reduce the pressure on auditors to maintain the absolute highest quality? Does it affect the report's credibility in the market? It's a valid debate.
That's a really fascinating tension. The attempt to limit liability, possibly undermining the very trust the audit aims to provide. What about other ways to limit liability, maybe more direct agreements?
Well, another tool is Liability Limitation Agreements, or LLAs. These have been allowed in the UK since 2008 under the Companies Act.
Okay, LLAs, how do they work?
There's specific clauses put into the engagement letter, the contract, that cap the maximum amount of compensation the auditor would have to pay if something goes wrong.
A cap on damages?
Exactly. But there are catches. They have to be approved by the company's shareholders every year.
Shareholders have to agree to limit their own potential claims.
Yes, and if it ever gets tested in court, a judge has to deem the cap fair and reasonable.
That sounds incredibly complicated to get right in practice. How do you even decide on a fair and reasonable cap before anything has even gone wrong?
It's a minefield, honestly. Huge practical problems. How do you set the cap? Is it a fixed amount? A multiple of the audit fee? Proportionate to blame. It's very hard to judge what's fair and reasonable before you know the scale of any potential issue.
And why would shareholders agree to limit their own recovery?
That's the other major hurdle. Shareholders often lack motivation to agree to these. Plus, there's a potential issue for directors recommending an LLA. Could they be breaching their duty to act in shareholders' best interests by suggesting it?
Tricky.
And the existence of an LLA also has to be disclosed in the company's financial statements. So it's quite complex.
So with all these challenges joined and several liability being tough, LLAs being complicated, what about proportional liability? That idea comes up a lot, making auditors pay only their share of the blame.
It's definitely a significant ongoing debate here in the UK. The idea is simple. The audit firm pays only its proportion of the fault or compensation in a negligence case.
Instead of potentially the whole amount.
Exactly. Australia actually adopted a form of this system back in 2004, so there is a precedent we can look at.
And the argument for bringing it to the UK is fairness.
Yeah.
And helping competition.
That's precisely the argument. Proponents say it would lead to a fair outcome, assigning responsibility where it actually lies.
Right.
And crucially for the market structure, it's believed it would help lower the financial barriers for firms wanting to enter the FTSE 350 audit market, mainly by reducing those crippling professional indemnity insurance premiums we talked about.
Okay, so looking at where we are right now, are these rising costs and the current liability system actually impacting competition? Are we seeing shifts in the market?
They absolutely are having an impact. The trend of rising litigation costs, the insurance issues, it arguably makes auditing the largest listed companies potentially prohibitive for many firms outside that very top tier.
Still mostly the big four then.
They still dominate, yes. But we are seeing some movement. Firms like Grant Thornton, BDO, Mazars, they are increasingly picking up statutory audits of UK public interest companies.
So some diversification is happening, but maybe slowly.
Exactly. It indicates some gradual change. But breaking into that top level consistently remains a huge challenge, partly because of these liability issues.
And what's the government doing? Is regulatory reform happening to tackle this?
Yes, there's definitely activity. The UK government has been focused on audit reform. We had major reviews like the Kingman Report.
Right, that led to strengthening the FRC?
Exactly, strengthening the powers of the Financial Reporting Council, the FRC. And the plan is still to eventually set up a new, stronger regulator, ARGA, the Audit, Reporting and Governance Authority.
But that's been delayed a bit.
Legislation has been delayed, yes, partly due to COVID-19 disruptions and other priorities. But the FRC isn't waiting. It's already operating with more capacity, issuing heavier fines, and really challenging poor quality audits much more forcefully. The regulatory pressure is definitely on.
So things are moving, albeit maybe not as fast as some would like on the legislative front. Okay, just to bring things together then, what are the absolutely key things auditors themselves can do proactively to reduce their exposure in this complex environment?
Well, number one is embracing those revised quality management standards from the IAASB we mentioned.
The ISQMs?
Yes, that means really thorough staff training, especially on risk assessment. But fundamentally, it's about cultivating that firm-wide culture of quality and best practice. It has to be embedded everywhere.
From the top leadership, setting the tone.
Right down to the junior auditor on an engagement team. Quality has to be everyone's responsibility.
Okay. So we've covered a lot of ground today on this deep dive into auditor liability. We've looked at the types of liability, criminal, civil, contract, tort. We saw how landmark cases like Caparo and Bannerman really set the rules, especially around that crucial duty of care.
Yeah, they're pivotal.
Then we tackled the really thorny issue of joint and several liability and the big challenges that creates.
It's a huge point of contention.
And finally, we looked at the toolkit auditors use to manage their risk focusing on quality, using disclaimers, the complexities of LLAs, the debate around proportional liability, plus the ongoing government reforms.
It's a complex picture.
It really is, which sort of leaves us with a final thought, maybe a question for you, the listener, to ponder. Given all these complexities, the push for more competition, the absolute need for high-quality audits, how can the system strike that right balance?
That's the million-pound question, isn't it? How do you ensure adequate compensation for those who are genuinely wronged while also maintaining a robust, competitive, and sustainable audit profession for the future?
It's a delicate balancing act.
And one that's definitely still evolving. Under immense scrutiny, finding that balance is key.